good morning, everyone. Welcome to the April 6, 2022 edition of the Kansas Court of Appeals. I'm Judge Anthony Powell, and I'll be our presiding judge this morning. With me on the panel are two very distinguished judges. We have our most senior judge in our court, Judge Henry Green, and one of our senior judges, retired district court judge, Richard Wachter. We have our third case, last but not least, case on the docket remaining. That case is Susan Taylor versus William Wachter as special administrator for the estate of Joan Warner Huff, deceased. Case number 124107. And could the court have the appearances of the appellant, please?
For appellate Susan Taylor, Angela Spigarelli.
Thank you very much. For the appellee?
May it please the court, the appellee, William Wachter, is the special administrator of the estate of Joan Eileen Warner Huff, appears by and through counsel Richard Billings.
Thank you very much. We've assigned 15 minutes aside for oral argument this morning. We've read your briefs, and so we are familiar with the facts of the case. Ms. Spigarelli, would you like to reserve any time for rebuttal?
Yes, maybe 2 minutes.
2 minutes?
Yeah, thank you.
You proceed. You have 13 minutes.
May it please the court. Good morning. I'd like to just give you a little bit of background. I know you've read the briefs, but give you some facts that we think are important. This is a negligence action that arose out of an incident back in 2010. It occurred on the defendant's property in Coffeyville, Kansas. The defendant, who's now deceased, was a lifelong veterinarian. She owned her own clinic there in Coffeyville, Kansas. And the plaintiff, Susan Taylor, was employed by her at that veterinary clinic. But this happened at the defendant's residence. So she was not on the job at the time, and she was not working or being paid. So the defendant had asked plaintiff to come to her house on her day off to help her vaccinate her horses, her personal horses, not horses that were part of the clinic. And, plaintiff testified that she felt like she had no choice, that her job depended on it, because she asked her several times throughout the day when she was on the job. So, she felt like she had to go. So she did. What she didn't know before she got to the defendant's property, she had never been there before, to her residence, was that some of the horses that needed to be vaccinated were wild and unhandled horses. And what she also didn't know is that the defendant didn't have adequate facilities to do this. There was a bunch of horses. There was 2 different groups of them, and she simply didn't have the right facility to do this. So they were able to get a first group of the non-wild horses vaccinated, but then the defendant herded in a second group of wild horses, and they couldn't get them properly worked at this facility. They were all sort of standing. There were no pins or chutes or anything. They're all standing there together. So as a result, they had to improvise, and they had to run the horses into a stock trailer to confine them in order to give them the vaccination. And plaintiff was standing on the side of the trailer. She's trying to get those vaccinations inside through the window. The horses became agitated. It knocks around the trailer, and she falls off, causing her injuries. So that's the background. Now, the trial court granted summary judgment on plaintiff's negligence claim. So there was no issue of material fact. Okay. And the second part was the trial court said that the plaintiff's claims were barred by the domestic animal activity. So I'd like to just separate those two and start out with the plaintiff's negligence claim. So the first negligent claim was that the defendant failed to maintain adequate facilities for this kind of activity. So I know you read the brief, but in Kansas, the duty owed by a landowner to invitees is Reasonable care under the circumstances. Okay, and there's 4 factors to be considered whether in the maintenance of the property, the landowner exercised reasonable care. And those 4 factors are foreseeability of harm to the entrant, magnitude of risk of injuries in others and maintaining the property in that condition. The third one is the social benefit of maintaining the property in that condition. And the 4th one was the burden of providing adequate protection against the condition. And as far as foreseeability, the first factor in proving negligence, that means that the landowner knows or reasonably should know that their action or failure to act will result in harm. And whether the risk of harm is foreseeable is a fact question for the jury. Now, the trial court ruled that analysis that I just went through was the wrong analysis, because the trial court said that would be in reference to a condition on the property, and that the plaintiff didn't allege that a condition on the property caused her injury. Rather, the trial court found that she was injured in the activity that she was doing, which is vaccinating horses. The plaintiff contends that this is where the trial court erred, and it's that same theme all throughout these counts as we go through them. The plaintiff did allege that the condition of the property caused her injury. The facility that the defendant had was run down. There's broken fencing. There's no squeeze chutes there. It just wasn't an adequate facility to get the amount of horses and the nature of these type of horses done. So that, and combined with the nature of them, and by the way, sorry, I interrupted myself. By the way, the defendant did have an alternate facility. It was down the road a little bit that did have all of the proper chutes, all of this type of thing. So both, plaintiff, her husband was with her vaccinating these horses, which is who the defendant hired to come do it. She just wanted plaintiff to come with her husband. They had asked several times if they could use this other facility that did have adequate fencing and, the right squeeze chute and that type of thing. But the defendant repeatedly told them no. I am assuming because they would have to transport all of the horses down the road. But for whatever reason, she said no, and she kept having them do this work at the facility that wasn't adequate. So because of this, they were forced to improvise using this trailer method. So it's like a makeshift chute where the horses are forced in there and they're isolated. And then they would reach in and, give the vaccinations. And that is what.
Don't I recall correctly that it was Ms. Taylor's husband who suggested using the trailer? It
is. And there was a lot of emphasis on that by both the defendant in their brief and the trial court. But what I would say to that is they were forced to come up with that as a last resort, because this facility was inadequate. They asked her several times if they could stop, continue a different day, or go to the adequate facility, and the defendant continually said no. So while her husband did come up with that idea, he had no other choice.
Could she have not have said, no, this is too dangerous, I just can't be a part of that? Particularly in light of the fact that she was, she wasn't a neophyte. She'd been around horses, experienced them, knew they could be dangerous in people working on them, and knew that these were wild. So I'm having trouble figuring out why in that situation, if it was this bad, and she knew it was bad, and you knew you were dealing with really possibly uncontrollable horses, why she didn't say, hey, I want no part of this. This is way too dangerous for me.
A couple things. So thank you for that question. So plaintiff, you're right. She is a lifelong horse owner, but she had never had experience with these type of wild horses. She has her own quarter horses that are family. She grew up having horses as a child, and her husband have horses, but she's not a veterinarian, and she definitely doesn't have any sort of insight on what method should be used. The second part of that is, who is an expert is defendant. She is a lifelong veterinarian. She has vaccinated all kinds of horses and owns wild horses, which, by the way, she owned them, she said, I think just as a hobby. So if anybody should have said this isn't an appropriate or safe manner, it would have been the defendant, who is an expert and a veterinarian.
Thank you.
So I go back to our original point. The proper analysis is whether the defendant failed to exercise reasonable care under the circumstances to present foreseeable harm. And that is a fact question for the jury, and the court should not have decided that as a matter of law. The second negligence claim was failure to warn of a dangerous condition or dangerous activity, same thing, on the property. So in Kansas, a landowner has a duty to warn any entrance of a dangerous condition. And the same goes for activity. I'm calling this an activity. Now, the defendant argued, and the trial court agreed, that the defendant had no duty to warn of a dangerous condition that is known or obvious, and that plaintiff was aware of the risk because she's a lifelong horse owner, and that she could have just left. Plaintiff did testify several times. Not only did she not feel like she could leave, she thought she had to go over there. There's a duress element here. So I guess the day before this happened, the defendant followed her around, asked her several times while she was on the job, are you coming over tomorrow? Are you coming over tomorrow? And so she really didn't feel like she had a choice in going over there, and definitely in leaving. But what I would say this is that she didn't have the opportunity to realize the danger until it was too late. So the second group of horses comes out after the first group. And, that in combination with the condition of the property, I think it's too simple to say, well, when she got there and she saw it all, she could have left. The activity was underway and the danger changed as the day went on. Not lastly, but almost, there was an emphasis on the McCubbin case by both the trial court and the defendant's briefs. And that case is I think it was a grocery store owner hires a guy to come trim his trees on the property. And that guy brings a buddy. So while they're trimming the trees, this buddy, or this, I guess a subcontractor of his, gets injured. The tree limb swings and hits him in the head, and he's injured. That case is not factually similar to this case, because in that case, there were no defects in the property alleged at all. He was just injured doing the activity he was hired to do, which is tree trimming. That is not this case. The plaintiff has always alleged that the defendant's defective condition of her property is what led to her injury, and the lack of proper equipment, or I would say unsafe use of the equipment she did have, which would be the trailer. The trailer's not meant to, that's not what a trailer is meant for. It's not used to be a makeshift horse chute. That is what ultimately led to her injury, not the activity itself. And that's really the key here. And, this may be oversimplifying it, but, if you hire someone to come over and mow your lawn, they're an independent contractor, and while they're working, he cuts his hand off in the blade. Okay, so that's not a case against the landowner because he got injured doing a job he was hired to do. If you hire someone to come mow the lawn and you don't tell them you've got a couple sticks of dynamite buried in the backyard and he gets his hand blown off, that's a different scenario. And that is what I like in this too. One is being injured in the activity itself, and that's what you were hired to do. And one has something to do with the property. And that's what this case is. I won't go through all of the domestic animal exceptions, but what I wanted to note is that, the trial court agreed with the defendant that plaintiff assumed the risk while engaging in domestic animal activity. But there are clear exceptions linked to everything we just talked about under KSA 60-4003. And there's a PIC instruction that mirrors that, which is PIC 12695. There are clear exceptions. I mean, there's not a blanket immunity if you are engaged in domestic animal activity. And they are, and again, here we are back to the equipment. The first exception is the domestic animal professional provided faulty equipment. Yes, sorry.
Sorry to interrupt you, but you have used up your 13 minutes. Do you wish to wrap up, or do you want to use some of your rebuttal time?
I'll just wrap it up because these exceptions go to the arguments I already made. There's faulty equipment. There's failure to make a reasonable effort to determine whether this participant could manage these type of animals. Again, we had some surprise wild horses come out that plaintiff didn't know about. And there is participant sustained injuries because of a danger that the landowner knew or the professional knew that she didn't. Again, we've gone through that. And lastly, that the activity fell below the standard of care. Again, the defendant is a veterinarian and a professional and should have known better than to subject the plaintiff to this activity. And for those reasons, we ask that you reverse the trial court in their summary judgment ruling. Thank you.
Thank you, counsel. Mr. Billings, you have 15 minutes. I'll give you kind of a generous 15 minutes.
Thank you. May it please the court. The district court ruled based on the issue of duty. There's no issue in this case of whether there's a factual question of breach, injury, or causation. And the appellant's arguments in this case are really focused on that there's a factual question of whether duty was breached. And it's our position that the district court properly found that the defendant did not owe this duty that appellant claims exists. And so the appellant's argument is that the defendant, as a landowner, had a duty to exercise reasonable care. Our law in this state is well established that the duty of a landowner to exercise reasonable care is not absolute. Foreseeability does not come into the question of whether a duty exists for a premises liability case when the danger is an open and obvious condition. One of the cases that we cited in our brief was an unpublished decision where a panel of the Court of Appeals considered a similar issue in Diddy versus Chapman, which is Appendix 1 of our brief. And when analyzing the issue, I thought the panel did a very good job of addressing a similar argument by the plaintiff in that case, that simply because there was a foreseeability of harm to the defendant, that established a duty upon the premises liability owner. And what the panel found was that under premises liability law, the foreseeability analysis differs from general negligence claims because under our law, there's no duty to remove or protect or warn of known and obvious dangers. And that's what we have in this case.
I'm sorry, what case were you, counsel, what case were you citing?
It's the unpublished opinion of Diddy versus Chapman. It's at Appendix 1 of our brief. And I understand that it's unpublished, but I was reading through it this morning, and I just thought the panel in that case really did a great analysis of kind of going through Kansas law on this issue. And so, you know, what it really comes down to on open and obvious dangers and the lack of the duty is a balance between the knowledge of the landowner and the injured party. And in situations such as this case, where the knowledge of the two of the dangers in the situation are equal, then there is no duty. And so for a defendant landowner to have a duty to warn or protect someone that comes on their land from some type of dangerous activity or condition, our law provides that they have to have some superior knowledge, because otherwise the injured person is free to make their own intelligent choice about whether or not they want to encounter the risks of that danger. And so what we have here is a lot of arguments by the appellant that before I got to the property, I didn't realize what I was about to encounter. And so if I have an old well that's uncovered on my property, and I have a friend come over and they're not aware that that well is there, but when they get there, they see the well, and for some reason, they decide to try to jump over the well and fall into it. I'm not responsible for that under Kansas law because they knew about it before they engaged in the activity of jumping over. Similarly, if my elderly neighbor asks me to help her clean out her gutter, and she provides me a ladder to use to climb up the ladder to get leaves out of her gutter. Certainly, we both recognize that it's foreseeable that I might fall off that ladder when I'm going up there, but we both recognize it. So she doesn't have to warn me before I walk up the ladder that, hey, you might fall if you walk up this ladder. She doesn't have to give me a lanyard or some safety mechanism to hold me in case I fall off the ladder, because I recognize that I'm going to encounter that risk. And whether I'm doing it for pay or gratuitously, I've knowingly made the choice to encounter that risk, and thus the other party has no duty. And so I think if we look at this like the district court did under a duty analysis, the duty just doesn't exist in this case, because the transcript of the plaintiff's deposition, which I conducted in this case, is part of the record. And in that deposition, the plaintiff admitted that she recognized the risks that she was encountering. The whole idea that before she got there, she didn't know what she was about to encounter doesn't matter. Once they deal with the first set of horses, Defendant Huff brings up a set of approximately 20 horses, and these horses are snorting, they're shuffling their paws, they're kicking at each other. One tries to kick the plaintiff's husband. And so the plaintiff's husband says, you know what? Here's a safe way that we can accomplish this task. I've used it hundreds of thousands of times. The plaintiff herself said she's used it in the past to do this same procedure. And so the idea that this was some type of defective or unusual use of this gooseneck trailer is not supported by the record evidence in this case, because plaintiff and her husband both said this is something that is used to do this procedure. And so the important time is before the plaintiff climbs up onto that side of the trailer. What did she know? Well, what she knew was that there were some extremely unhandled and wild horses that were behaving in a manner that was unlike the horses that she owns. And they were being aggressive. And this is when they're not confined. This is when her husband's not holding a rope around their neck, trying to pull them to the side of the trailer. She recognized and admitted, I had concerns that I might be hurt if I get up there and I try to do this. She knows she's going to be climbing on an elevated surface 3 feet from the ground. And she knows that one of the risks is I might fall if I get up there and do this. And that's exactly what happened. The defendant is standing on the side of the trailer, handing her the vaccinations. There's nothing that she knows about using this procedure that plaintiff's husband developed that plaintiff and her husband don't know. The argument by appellant that she was under some type of duress is not supported by the record in this case. When I took the plaintiff's deposition, she testified that she did feel like she had some pressure to come out there with her husband that day. But she was very clear when I asked her, my next question was, well, once you recognized that these horses were wild and that you were getting ready to climb up on this elevated surface? Was there anything at all that prevented you from leaving at that time? No, nothing prevented me from leaving at that time. The only thing I was worried about at that time is if I didn't do it, the defendant Huff might encounter that danger and try to do it herself. And so this idea that she made some decision under duress, one, I don't think is an exception from the lack of a duty under an open and obvious condition issue, but two, it's just simply not what the facts of this case are. I mean, the appellant made some arguments today that the defendant has lifelong experience as a veterinarian vaccinating wild horses. There's no record evidence. There's nothing in the record that she had done this type of procedure. She hired an independent contractor, the plaintiff's husband, who touted his lengthy experience doing this. He came up with a procedure that both he and the plaintiff felt like was safe to do, and plaintiff was injured while doing it. And there's many cases that we've cited in our brief that says when you hire an independent contractor to perform work on your property, you don't have a duty to protect them. You don't have a duty to provide them a safe place to do so. The idea that we had this other facility that could have been used is a red herring in this case, because it wasn't being used. There was no, if defendant actually said, no, we can't go use this facility, which you have to, taking the facts in the light most favorable to plaintiff, you have to assume she did, then plaintiff and her husband were free to leave and say, we're not going to do it without using the facility. But instead they said, we're going to do this because we think it's safe. And so it's our position that the district court properly found that under plaintiff's theory of premises liability law, that the defendant owed plaintiff no duty to warn her, protect her from the open and obvious risks of the activity she voluntarily agreed to participate in. There was a comment made by appellant's counsel that this was similar to a situation where there's a couple sticks of dynamite buried in the yard. I mean, this is far from that type of situation. There's no sticks of dynamite hiding under the trailer. There's nothing, the trailer itself, it's uncontroverted, was not defective. It was suitable for that purpose. That's why there's a fender on there, and plaintiff told me in her deposition that this fender is extended the way it is so that people using these trailers can get in there and work on their livestock. And so the idea that there was some type of hidden danger like dynamite buried in the yard is just completely not supported by the facts in this case, because there were no hidden dangers. I mean, if there were some type of hidden dangers, then it would be a different analysis, but none of that has been argued in this case. As to the domestic animal activity doctrine, we don't believe that the district court even necessarily would have had to get to that issue to grant summary judgment in the case. Because of the lack of duty, we were entitled to summary judgment on the negligence claims. But we do believe that it was appropriate for the district court to say there's a separate reason why the defendant is entitled to summary judgment because of that doctrine. Now, this is another question of law for this court because it's a matter of statutory interpretation. Our legislature has determined that when a participant in domestic animal activity does that the domestic animal activity sponsor has an affirmative defense that they assumed the risk. And if we look at the definitions within the statutes, plaintiff meets the definition of a participant, and the activity she was engaging in meets the definition of a domestic animal activity. A horse is a domestic animal, and the defendant meets the definition of a domestic animal activity sponsor. And I won't go through each and every one of the exceptions contained within the statute, but the significant part about each of those exceptions is that the plaintiff would have to provide evidence that those exceptions would apply. And a careful review of the record evidence in this case simply shows that none of those factors apply. I mean, the first one is that there was some type of faulty equipment that caused the injury. The appellant wants to say, well, we've argued that there was faulty equipment because the trailer shouldn't have been used to do this. Well, that's what they decided to use. And there's no evidence that there was any condition of the trailer that itself was faulty. The appellant wants to argue that, well, a lifelong veterinarian didn't meet the standard of care when it comes to what another domestic animal activity sponsor would do. Well, in this case, if this matter would have proceeded to trial and 12 members of the jury were asked to decide what is the standard of care for a domestic animal activity sponsor, that wouldn't be within their common knowledge and experience to determine. And so plaintiff was under the obligation to present some evidence that defendant Huff's conduct fell below the standard of care for a domestic animal activity sponsor in the same locality. And she didn't designate any expert to do so or provide any other admissible evidence to support that exception exists. And so under these circumstances, we believe that no exceptions to the domestic animal activity doctrine existed because there was simply no evidence to support any of those. And so members of the panel, we'd respectfully request that you affirm the district court's rulings because they were proper under the circumstances of this case. That simply because the plaintiff was injured does not mean that a negligence claim exists. They have to prove the essential elements of a claim, and that includes duty. Because duty is a question of law for the court took the facts in the light most favorable to the plaintiff and made the determination that because our law does not require landowners to protect, remedy, or warn people of open and obvious dangers, a duty simply doesn't exist in this case. And that was the appropriate decision in this case. And for all those reasons, we'd request that you affirm the district court's decision. Unless the panel has any other questions, I think my time is up, and that's all I have.
Thank you, counsel. Any questions from the panel?
No.
None. Ms. Spigarelli, you have 2 minutes.
Okay, thank you. I just wanted to point out there was a lot of talk just now about they advocated, meaning her husband and plaintiff. Plaintiff didn't advocate anything or come up with this idea for the trailer. Her husband did. But I mean, this is plaintiff's case against the defendant Huff, who is a veterinarian. So to group them together and say that plaintiff and her husband came up with this isn't correct. It was plaintiff's husband, and this isn't plaintiff's husband's case. It's plaintiffs who got injured on defendant's property. So I want to be real careful not to mix the two of those. And I think there was also mentioned that plaintiff had done that method before. I believe in her deposition, she said she had done it once before, but definitely not with wild horses. So again, there's a distinction, and I'll leave you with this. These are negligence claims, and there's too many fact issues, and the jury should be deciding, well, did she have the right experience or not? I know, is there a difference between quarter horses and wild horses? Should she have left? Did she feel this duress? All of these are fact questions for the jury and should not have been decided by the trial court in summary judgment. So again, I ask you to reverse that decision. Thank you.
Thank you very much, counsel. Any questions from the panel? Seeing none. Counsel, I want to thank you both for your excellent argument this morning. We will take this case under advisement and we'll issue a written